Good morning. Thank you for joining this session, the book session, Industry Unbound. Special session on a book written by Ari Waldman, the author, who's right here. Maybe can one of you just hold the book up for a second? So that's the book. So thank you for joining us. So in his book, Industry Unbound, the inside story of privacy, data, and corporate power, Ari Waldman shows how tech companies undermine privacy protections in practice. Building on years of research and interviews with privacy lawyers and professionals, his book reveals the layers of the tech industry's stranglehold over privacy regulation. By dominating discourse, compliance, and design, the tech industry has managed to stack the cards against us, and so effectively co-opt the privacy profession, such that even those who call themselves privacy advocates on the inside do not realize how they are complicit in oppressive data extraction. So in this special CPDP session, we have the author to give a little introduction to his book, and then we have two discussants to bring up some of the main themes for discussion of the session, to give a reaction to the book. And so we'll open up with a presentation by Ari Waldman, and then we'll have the two discussants give some remarks, and then we will hopefully open it up pretty soon also for like a discussion with the audience. Let me introduce our speakers. Ari Ezra Waldman is a professor of law and computer science and the faculty director of the Center for Law, Information and Creativity at Northeastern University. He researches the ways in which law and technology reify traditional structures of power, with particular focus on privacy, misinformation, and the LGBTQ+ community. So Ari has written a ton, is super prolific, and the one thing that I will stress also in terms of his background is that Ari has a degree as a PhD in sociology. So his work is really exemplary of combining these fields, law and sociology, and like a very strong kind of social legal profile, which I think is fantastic. And one of the kind of reasons why I was really happy to be able to host this panel at CPDP is because I'm hoping that like more of that type of work could also be done in a European context. So as discussants, we have first Svetlana Yakovleva from the University of Amsterdam, the Institute for Information Law, where she's a postdoctoral researcher. She also works part-time as a senior legal advisor in privacy data and cybersecurity practice at De Brouw Blackstone Westbroek in their Amsterdam office. So it's like one of the high-end law firms in the Netherlands, also doing quite a ton of work on data protection. Her research cuts across different areas of law, such as privacy and data protection, European law, international trade law, antitrust, consumer and cybersecurity law, and with a particular focus on data governance. Svetlana wrote her PhD dissertation combining the different perspectives of international trade law and EU data protection law. And our second discussant is Rowena Fielding, also known as Miss IG Geek. Rowena has been a data protection practitioner for more than a decade, advising commercial, business, and non-profits in a wide range of sectors and industries. In 2021, Rowena authored the Data Protection Competency Framework for Building Organizational Data Protection, Culture, and Quality. She works as a freelance data protection consultant under the brand Miss IG Geek Ltd. Thank you so much for joining us, and I'll give the floor to Ari to kick it off. And you can also stay on the...
Have to sit a lot. Thank you, everyone, for being here, and thank you, Joris, for organizing this panel, and thank you in advance to the commentators who come at this discussion from a variety of backgrounds. And I'm looking forward to hearing the good and the bad, the critiques and the support. Again, my name is Ari Waldman. I'm a professor in the States. And this book is the result of a little under 4 years of research. Sometimes empirical, on-the-ground research takes a really long time. And it was an interesting time to do this research because it spanned the publication of the draft text of the GDPR to the enactment of the GDPR to after the enactment of the GDPR. So I got a chance to see what companies were actually doing, not only with respect to complying with the GDPR, but partly that. So this book is about the liminal space between formal law that you might pass anywhere, whether it's a state in the United States, a federal privacy legislation, or the GDPR, and practice on the ground, right? So as any lawyer knows, like, you can pass whatever law that you want, but the way individuals and the way people experience that law is often tangential to the actual words of a law. In that space, right, it's both temporal as well as metaphorical. It's temporal in the sense that between the time that a law is passed or a law is enacted or takes effect and the time that some of the words in that law are interpreted or given effect, right, there's quite a bit of time. There has to be some decision or some opinion report or some decision by a court to clarify what a particular statute means. In that time, who gets to decide what the law means? Well, it's not us, and it's not the people who wrote the law, it's the people who are applying it. In this case, when we're thinking about data-intensive industries, like the information industry, we're thinking about companies. Technology companies are the ones that get to determine first what laws like the GDPR or new laws that we're passing or states are trying to pass in the United States, what those laws mean. And when that happens, they interpret it with the help of lawyers, with the help of privacy professionals, with the help of designers, executives, engineers, people who have no training in the law whatsoever. They interpret those laws in ways that support their goal. And their goal, of course, is profit. But what happens in this space is interesting in that it's different than other areas. It's different and similar than other areas of law. Here, laws like the GDPR explicitly envision an army of people who are inside a company who are supposed to be the ones to apply the law with some manner of independence from that company, right? Because the premise is that there's some tension between protecting individual privacy, protecting privacy of the data subject, and the otherwise profit-making goals of the company, right? That's not always true, but there is at least a premise that that is the case, and that privacy professionals are there, privacy professionals, privacy engineers, privacy advocates, people who are supposed, and privacy lawyers, people who are inside who are supposed to take this law, take this formal law, and translate it into action, translate it into something that the company will do. What does privacy by design and by default actually mean? What actually has to be in an impact assessment? What kind of records do we actually have to keep? What kind of access? What is the role of the privacy professional in design of new products? Can a privacy professional say, we're simply not going to do this, not going to sell or market this product, this information-intensive product, because of its privacy concerns? Who gets to determine when the privacy impacts are so significant such that a company does not proceed with a particular product or platform? So I went inside companies to try to find out how this process works. This book is a product of an ethnography and observations of 3 companies. I had an opportunity to be embedded inside these companies. We can talk a little bit about methods if you'd like, but it's not a super, that kind of conversation. Many people who aren't academics or sociologists, their eyes glaze over and people fall asleep. So if you don't want to talk about that, that's fine. And to fill in some of the gaps, I also interviewed current and former employees of some of the largest tech companies in the United States. So to be clear, this book is not about how every single company operates, nor is it about a necessary or deterministic plan about what will happen always after we pass a law. It's a story about how these companies operate with respect to privacy and data protection law of all sorts. So what I learned is that not only is there no such thing as a fully independent or an independent agency or structure inside a profit-making corporation. We already knew that, right? You don't need a 300-page book to tell you that corporate organizations or capitalistic organizations are organized for profit. But what's interesting about privacy professionals and the relationship between people who are responsible for privacy inside these companies and the organizations themselves is that the organizations take people who otherwise seem to really care about privacy and undermine their work so persuasively and so through and through that they don't even realize how their work is being manipulated or used for data extractive ends. So what I mean by that is I'll explain through some examples. I met people who would talk about how I am the person that a company hires when they care about privacy. That was a statement by one of my interviewers, word for word, one of my interviewees, word for word, and it's a common theme. Lots of privacy professionals and privacy lawyers come into this work truly believing that they are going to be the ones that are going to change how a company operates, that they're going to be the ones who, because they care about privacy so much, they're going to change how this company works. And they actually really do believe that, and even being inside the company, they still believe it. But what turns out is when you look at the impact, the relationship between a privacy professional or a privacy lawyer or a privacy engineer and impact on products, there's a disconnect. So here's a good example. I was embedded inside a mid-size information company that they design an email platform, a communications platform. And I had to sign confidentiality agreements because this, if you read the book, there's nothing proprietary in it. I'm only interested in process, so I can't tell you the names of the corporations. And I met with their privacy team. And the privacy team was 6 people, including lawyers and non-lawyers. And they were ecstatic to talk because of all the work they were doing for the past several years. Look at this, look at our work product, they said. Look at all these, and they actually had printouts. Like, look at all of our paperwork. Look at all of the stuff that we've been doing. Okay, what have you been doing? We have new policies and impact assessments. We designed new ways for all members of our team to do impact assessments really easily. We helped hire new privacy engineers. We wrote these policies. Look at all these things that we've been doing. Okay, that's wonderful. Really great for a sociologist. What impact have you had on products? And I got blank stares. There had been no change in the defaults of the products that this company was putting out. There had been no change in the company's defaults of how they were collecting data. No change in how the company understood their relationship between data and profit. No change in our experience, consumers' experience with respect to our privacy, relative to this company's product. The impact that they had were things like, well, our privacy policy is far more understandable. Our privacy policy now is layered, so people can click on these buttons and understand the document better. Or our engineers now have a chart or a box, a template for filling out an impact assessment, right? That's easy for everyone. Now it's easy. Unfortunately, easy is good, but also easy is just checking a box a lot of times, right? So the impact that they were having was not only minimal, but also the impact that they were having also was in a very narrow space with respect to privacy. So here's another example. So I was meeting in a different company, I was meeting with the group of their privacy lawyers. This company was big enough to have a privacy legal team. Facebook and Google, they have hundreds of privacy lawyers. This team had 8. And they were involved in various litigation associated with collection and distribution of data. So I asked, so can you tell me a little bit about how, I asked them to tell me a little bit about how they saw what they did during the day. What was their typical day for a junior, mid-level, and the general counsel at this company? The juniors midday involved things like updating privacy policies, writing a report about transparency meaning explaining our data collection practices, and doing research for briefs which I'll tell you about in a little bit. So this lawyer who graduated from a law school pretty recently in the United States and took privacy classes, came to do this job because they cared about privacy. Their entire job had been only about notice, choice, and transparency. Mid-level attorney, their job included, of course, working with a junior attorney on these things, but also included things like working with policymakers to think about what privacy legislation should look like. It also was more involved in writing briefs that this company was involved in. Okay, so what are these briefs? Well, these cases were all about whether individuals like us continue to have privacy rights on this platform after disclosure, right? It wasn't Facebook, but imagine Facebook, right? Like you disclose something on a platform, and these companies say that you continue to have privacy interests in or privacy in the information that you disclose. And in fact, they spent about 20 minutes explaining to me how extensive the privacy protections are even after you disclose information on their platform. So the mid-level lawyer, as well as the general counsel, was involved deeply in writing these briefs and litigation strategy. So I, of course, coming to all meetings prepared, I had the brief in front of me. So I said, well, how do you explain then that in this brief, you say that upon disclosure, users have no privacy interest in information shared on our platform, right there in black and white. And then the response from the general counsel was, well, nothing should stop me from being a zealous advocate for my client. So we teach that in law school. I'm sure you teach that in law school in Europe as well. But the zealous advocacy canon came up over and over and over again as an explanation, as an excuse for companies to lie to their users and then make arguments in their briefs about how privacy essentially does not exist. And then the final thing I'll say is about discourse. What was the role of these companies in establishing what privacy means or what data protection means? Because there, again, in that space, a court can say whatever it wants, a statute can say whatever it wants, but the discourse is often influenced by the people who are doing the most work here, by these reports, by statements, et cetera. Almost everyone that I spoke to in leadership at these companies conceived of privacy as managing your control over your information. And what they meant by that are these procedural safeguards. Well, yes, we can use your information as long as you've read a privacy policy, or we can use this information as long as we filled out a data protection impact assessment. And their limited view of privacy was so pervasive that even people who had come into work thinking or knowing much more about privacy, their impression when challenged, when asked, well, why don't you consider, what about, say, not collecting information about sexual orientation or gender identity? And then someone who had said to me, I consider myself a privacy advocate inside this company, simply said, well, that's not what we do. That's not what privacy law is, right? The law allows us to collect this information. It's about how we use it. So someone who considers themselves an advocate but then has a narrow perception of what privacy means, is going to be an advocate for an industry-friendly vision of privacy. Putting all this together, as well as many other things that are in the book, you have people who genuinely care about privacy, but whose work, based on how they are structured, how they are placed inside an organization geared toward data extraction, has their work either minimized or develops this kind of false consciousness about what they're doing. And that's an incredibly pessimistic vision, especially when we're living in a regime where laws explicitly envision them being bulwarks against data extraction. That means that laws like the GDPR are not just pointless, they're actually gifts to industry. And I often like to end talks in Europe with that line because it gets people really upset. So with that, I'll hand it off to my commentators.
Thank you very much, Ari, and also especially for the provocative ending there. Hopefully, like people can start to kind of formulate also their responses and questions. So, but first we're going to hear from our first discussant, Svetlana. Please, the floor is yours.
Thank you, Joris. Oh, it works. Thank you, Joris, and thank you for inviting me to this panel. And Ari, thank you for writing this book. I really enjoyed reading it, and especially as a legal researcher and lawyer with primarily legal background, I really found the methodology used to do the research very refreshing and very interesting because it brings up the issues that we discuss in legal research, but shows how that actually works on the ground and what people who are in charge of implementing those laws and designing technologies, what's going on in their minds. And I found the discussions that Ari reproduces in the book and the quotes quite depressing because it just goes on, and you think the question I had, and maybe a bit of hope, that maybe in whether you've seen any difference or in how those professionals on the ground see that in Europe, whether it is different from that in the US, given the difference in the privacy culture. Perhaps some of those things didn't make it to the book, but I would really be interested to see whether there is any significant difference between that. In my short intervention, I would like to give some reflections on the book more as a legal researcher and position the insights from the book in the European context. So the point about discourse, we can't emphasize enough how much more important the discourse and the framing of the issues is than the actually legislation itself. And I think also here in the conference, some of the civil society organizations mentioned yesterday that they feel like the GDPR was designed against them, not to help them. And unfortunately, the discourse around the designing the GDPR itself, it was all about giving users control. So the discourse of control was actually introduced in Europe and gifted to companies by the legislator. The GDPR mentions control of individuals over their data many times in the recitals. This was one of the selling points of the GDPR. In the mass claims litigation on data, one of the issues now is whether loss of control is damaged. So this issue of control keeps coming and coming back in different discussions. And I really found it very important that Ari shows us in the book that this actually weaponizes the GDPR against individuals and gives companies more power. And I think at the policy level in the EU, also at the societal level, there's more and more realization that procedural laws like GDPR lead to more impression of control and more sharing of data and more power. So the question is how to counter that power, how to protect not just the individual right to privacy and data protection, but more the societal values that are undermined by corporate power of information technology companies. And I think my impression in the EU that this discourse is diverging in two ways. One is the digital sovereignty discussion that in the recent couple of years came to the forefront and sort of took over the individual control or the user control over information. And so the GDPR is no longer seen as the data governance instrument, but just one of the pieces in the puzzle of data governance. And multiple data acts, DMA, DSA, that have been mentioned multiple times here at the conference, they're all created to counter the corporate power and to give more rights to enforcement authorities, to weaken the corporate power by data sharing, by prohibiting certain mergers of technology companies, by imposing more disciplines on large platforms, etc. Whether this will work, it remains to be seen, but my impression is quite pessimistic because in the end, each of these acts are created in silos and they create more siloed enforcement structures that have coordination mechanisms within them, but not between them. So in the end, there will be maybe more enforcement, but that enforcement will go to litigation because of the overlaps, and the duplication of efforts will not make it more efficient, also in light of limited resources that enforcement authorities already have. The other diversion of this discourse of control, I've shifted from the individual level to the collective level, and that is the collective enforcement of data rights, but also consumer rights. And the EU legislator also has strengthened those mechanisms by introducing the Collective Redress Directive, for example, and the recent interpretation of the GDPR by the CGU about the standing of consumer organizations also kind of goes in that direction. So the realization is there that individual control and the individual himself or herself themselves, they cannot push back alone against this power, so you need some collective effort. The problem with collective actions is that in the end, it still strikes back to a collective of individuals. It's not about the collective itself, but the parts of that collective. So I think these are important developments, but in the end, yeah, my impression is quite pessimistic on where this is all going. Another aspect of this issue that I wanted to raise is on the cross-country level. So when we talk about laws, we normally talk about the geographical areas where they apply, such as the GDPR in the EU. But at the cross-country level, I think an important issue that has to be discussed is the transfer of value and the power of populations to countries where information technologies are actually concentrated. Because when data flows, and there's a lot of discussion in trade agreements on free data flow and that we should have more free data flow because it's very helpful to develop technologies. But the question is where the technologies are and where the data comes from, and whether people from whom data was sourced actually have access to that technologies, and what are the conditions for that access, and whether they actually get some of the value back on the collective level, not at the individual level of each specific person, but as a population or society or community. And I think this is also a matter of control. So in the end, from individual control, we're going to control over decision-making power, over data and the data governance as a power to make decisions on who has the data, what happens, and who gets the benefits of it. Thank you.
Thank you. Thank you. Thank you very much. So I think we'll do is like we'll go for the second discussion right away for Rowena, and then we'll give you the chance to give a few responses, and then we'll open it up.
Okay, so I really enjoyed the book, mainly because it appealed to my confirmation bias, because it reflected what I see on the ground. So from my point of view, I work as a practitioner. I am not an academic or a lawyer. I work really in the SME space, small, medium enterprises, commercial and non-commercial. And what I saw in the book in big tech was reflected in my experience on the ground and my experience among a network of data protection professionals. So one thing that did keep me raising my eyebrows through the book was the characterization of GDPR as a privacy law, when it's not a privacy law, it's a data protection law. And the point of data protection law is that it's there to protect rights and freedoms, all rights and freedoms of living natural persons, which includes the right to privacy, but is not limited to the right to privacy. And in fact, in my experience, the pushbacks against abuses of data don't use from individuals aren't really about the abstract notion of privacy. They're about material impact on their lives in a way that's to do with other rights, so employment rights, consumer rights, citizen rights. So yes, I did kind of raise my eyebrows a few times. And I think that's really, really important to bear in mind, the terminology, and to not just focus on privacy, because by doing so you create another silo and another bubble which isn't connected to the other issues. We've built a world where pretty much everything is connected to everything else, but we're still thinking in ways that are pre-hyperconnectivity. and that makes a big difference. So in my work, I do a lot of talking to executives about human risk. And I find that there is an inherent tension between consideration of corporate risk, so operational, getting stuff done, commercial, making money, and regulatory, litigation enforcement. And there is a big tendency among the data protection profession, from my experience, of focusing on corporate risk, because that's the argument that executives understand. But again, that misses the point of data protection law. It's not about managing corporate risk so much as it is about managing human risk, and that human beings have inherent value, not just as meat units to be farmed for corporate profit. So when I talk to executives, I start with the premise that data is bits of people, bits of human beings, not just lines in a spreadsheet. These are real living people who have feelings and needs and stuff like that, which is usually quite a surprise, because datafication is inherently dehumanization. When you talk about people in terms of their data, you're missing their humanity. And the discourse around data and personal data has become, also by sort of corporate direction, a focus on how do we gatekeep the definition of personal data so that we don't have to think about what we're doing, because that's easier. So I think in terms of remedies to the situation we're seeing now, humanizing the data is absolutely essential. Basically shaming people into trying to do the right thing, and making them kind of bring back what they're doing to their idea of themselves as a good person trying to do nice things, albeit within constraints. So I am autistic, which means my hypocrisy radar is 10 million times more sensitive than most people's. And what I see in the practice of data protection on the ground is a big old pile of hypocrisy. I call it the paperwork reality gap. And in the paperwork reality gap is people being people. You can't stop people being people. But those people being people lack a sense of self-awareness, where they look at their actions, their motivations, their biases, their imperatives, and make rational decisions. I think a major flaw in the GDPR was the premise that people make rational decisions. People very, very rarely use reason. They operate on instinct and impulse, and because that's easier. Human cognition is built on shortcuts. And so we take shortcuts when we end up with what I call cargo cult compliance, going through the motions without really understanding why and what it is we're trying to achieve. And the difficulty there is that corporate interests are usually diametrically opposed to the interests of humanity and human welfare. And I think until we get to grips with that, it's always going to be an uphill struggle with lots of friction to embed the premises and the principles of data protection in business as usual. It's too easy to tick boxes, and it's very hard to think about people. We're connected to so many other people all at once now. We've got compassion fatigue. We can't care about everybody all at once. And when our group or our self-interest conflicts with the interests of other people, we other them to justify making decisions that benefit ourselves at the expense of others. And that's a fundamental of human nature we can't change, but we can be cognizant of it, and we can manage our own responses if we try. Unfortunately, the pursuit of profit growth and dominance tends to pull us in other directions. So the main barriers to the practice of data protection, which I saw in the book reflected from my experience, conflicting imperatives, us and them, me, you, them, us, perverse incentives, corporate power and profit versus humanity's welfare and social justice, although that's become something of a bad phrase these days. And the power dynamics of the collective versus the individual. If you look at how corporations, obviously the bigger the corporation, the more concentrated this is. If you looked at the relationship between the corporation and the individual in terms of, say, a romantic partnership, the corporation would be an abusive, narcissistic sociopath. Because the goal is to manipulate, to dominate, to remove agency in pursuit of that corporate organism's self-interest. Now, obviously, not all corporations behave like that. Smaller organizations with thoughtful executives tend to behave better. But certainly large organizations are emulating the absolute worst in human nature. And I'm not wholly convinced that this is any kind of conscious direction or planned or conspiracy. It's an emergent property of people being people in large numbers. But this is something that we need to take into account as data protection practitioners, as privacy practitioners, when we're doing our work on the ground. The whole deck is stacked against us. And the only way to punch through that deck and get people to behave in the best interests of other human people, not corporate people, is to go straight for the hearts and minds, the ethics, the human welfare, the emotional argument, which is pretty much the opposite of the just business approach. So, in conclusion, I would recommend that everybody working as a data protection or privacy practitioner should read this book and should self-examine and should do what they can to push back against human hostile interests wherever they find them. And I think the remedies to the patterns and the trajectory described in the book have to be combated by human-first, holistic practice. So not privacy in a silo, not data protection as compliance, but doing stuff in a way that causes the least harm to other human beings and weighing that against the benefit. That means making time and space for thinking, which is very difficult because the corporate environment is not big on giving people time and space for thinking. Thinking, in terms of productivity monitoring software, is indistinguishable from daydreaming. So the productivity software industry actually punishes people for being thoughtful and considerate and well-researched. So that's a dynamic that, again, I think needs to be pushed back on. And the corporate way is to seek speed, efficiency, scalability, and reduce friction. But actually, friction is a good thing. Brakes work on friction. To coin an analogy, the wondrous experience of physical intimacy depends largely on friction. Friction is good. And so I think, again, we need to be pushing back and pointing out the advantages of friction, both in the short and the long term, and making human arguments to appeal to humans to counter the inhumanity of corporate thinking.
All of that was amazing. I don't really have any comments or responses. Just one brief thing, and then I'd love to open it up for conversation and questions. The comment that you made about whether this is a concerted plan versus just people behaving like people, and I'm very clear in the book that I don't think that this whole story is a bunch of starts with a bunch of evil executives sitting in rooms with tented fingers like Montgomery Burns and The Simpsons, I mean, there are those people, right? There definitely are those people. But more often than not, it's far more Foucaultian in that these are little decisions being made to achieve other ends of the corporation that have the end effect of creating this pattern and creating these affordances of like this is just how people behave. Like I don't think a general counsel is assigning a junior attorney to write a report about transparency specifically because that general counsel knows that this is a really good way to distract them and to define the discourse and to co-opt their brain, right? But there's a path dependency from that general counsel who got that from somewhere else, that this is just how the corporation operates. So it would in fact be better if there were Montgomery Burns style executives. I mean, there are a couple. I mean, we should get rid of Mark Zuckerberg and so forth. But like, it would be better because that would mean that we could replace the leadership and have a better organization. We can't do that because it's built in. Whether you think that is a critique of capitalism or it's a critique of the manner of the organizational structure of late capitalism is up to you. But it's not dependent on evil for it to persist. I'll just leave it at that. So, any questions?
Yeah, let's open it up. There's a microphone in the room, probably. Yeah. So. Thanks so much for those great comments. That was a little bit of a throwback for me to the time of like the GDPR kind of preparations, and I remember I had like Twitter fitties with like one of the people working with Vivian Redding, who was like obviously not really a data protection kind of specialist, but like was in this field. And of course, I mean, it was very interesting at the time that Vivian Redding was like the European Commissioner in charge of the GDPR file, and the proposal was, really, like becoming like an entrepreneur, like a political entrepreneur on the basis of like owning this kind of file and bringing it forward. But she put such an emphasis on the control, even though like I think in the field at the time, a lot of us were like, we really should be moving beyond that. We are in a post-consent environment. Consent doesn't really work anymore. And then they were like, yeah, privacy is like data protection is property rights over your data. I was like, oh my God, what's going on here? So, but of course, in a way, it was super. It worked, in a political way, because maybe that's like, I mean, the consumer choice frame, of course, is not unique to data protection and privacy as well. But let's open it up and get some questions for the speaker and discussants too. Yeah.
It was a fascinating discussion, and just looking at this through the lens of data ethics and the work that's been done by people like Linda Trevino on business ethics, what you're describing is effectively situational moderators on ethical behavior in an organization. And just wondering, will the panel have any thoughts on that perspective? I know Rowena does. We've spoken about this many times.
So, could you just repeat the concept? Situational
Moderators of ethical behavior in organizations. So the effective governance controls and organizational culture.
Not being a lawyer or an academic, I'm not wholly familiar with all the technical terms.
Lawyers and academics aren't either.
Okay, fair enough. I would file that under people being people taking shortcuts with conflicting imperatives and perverse incentives. And humans are really bad at complex, long-term, long-tail risk management. We did not evolve for the world we've built. Our brains can't tell the difference between a charging saber-toothed tiger and a snotty email. And our governance dynamics that we work on, they don't work because they don't take into account the fundamental differences between human ideals and human nature. And this is the case with data protection, with climate change, with wealth distribution across the globe. So I think it's probably the same thing as you're describing. And we can give it specific terms, but we can't treat it in isolation. We can't pretend that this is anything but people being people and we can't fix it by anything but trying to be better than human.
I'll only add. I think that's right, and Rowena, you're really, really good at these fantastic turns of phrase, right? I wish I had that skill. Would have written a better book, but if I had that. So I think Rowena is right. I may be even more pessimistic, is that I think in the entire academic and professional industry around these internal ethical moderators of behavior is endogenous to industry because they want that to replace true public governance, right? Not just the world that we've built psychologically, but the neoliberal, what passes for public governance in the neoliberal era that we've been living in are these internal moderators of behavior, such that, these ideas of AI ethics departments inside companies. Well, if you can just fire an entire AI ethics department simply for potentially publishing a paper that potentially undermined the profit-making margins of your company, then you don't really have an AI ethics department. You have a marketing show. So these structures, these internal compliance, these internal structures of compliance are what my colleague Julie Cohen calls things on the periphery of the regulatory state. They are there because companies want them to replace true public governance. So the answer is not, I don't think, people, right? So the answer is not these people have to be better. It's that you can't ever rely on these people to achieve public governance goals. Do you want to call on people, or should we?
I need to.
Okay. Just move the microphone.
We just took care of the situation. Well, I was also a practitioner before getting into academia, and I'm so relieved to listen to what you've been saying because it kind of reflects also my experience. So, and I want to go through some things that I experienced in reality to check whether you have the same experience. So. What I've seen is that there is a really conflict between a discourse and action in companies and between legislator and companies. So, and this is kind of pervasive because I think when I see academics saying data protection is an asset, well, I didn't see that in practice. And I didn't feel that there was the way.
Can you hold the microphone?
Oh yeah, sorry. So, and this is about also. I find a problem, which is I don't think is just from my country. So there is a problem of literacy on recognizing the good of data protection in itself. So what I am pursuing, and this informs also the idea of risk. So the thing is, this is not risk for fundamental rights. This is the risk of being fined or for my reputation, and this already undermines the interpretative activity that you have on compliance. So I found this idea of risk and the incidence of risk a bit another conflict in discourse and practice. Don't know if you feel that also. So other compliance obligations, so the way we take care about compliance, either environmental, data protection. So this is kind of the social obligation part, which is not that it's not so much central to companies' concerns, at least from the leaderships I had an opportunity to engage with. So I don't know if you also had that feeling. Also on SMEs, the client pressure. If you have highly concurrential markets, highly competitive markets, where the client can simply move to a company that does what the client wants, even if it's uncompliant. So, and this is, again, is not the intention of the companies. These are not evil persons. People people being people. And I think this is not sufficiently underscored in the data protection field. Again, also, internal relationships between employees and with employees and leaderships also massively influential on the end result of compliance. And finally, cross-country, the culture of companies. I've worked with multinational companies that had an American way of interpreting, and they had all the paperwork done, and national companies who didn't have that. This is also a factor that I found. So if you could just comment a bit on this, and also on other factors that you've seen that influenced compliance on the ground and the mismatches between discourse and action.
I mean, I would definitely say that there is a huge knowledge gap, and the knowledge gap is increasing every minute. The amount of things that people need to know in order to do any part of any job properly, because we keep refining and refining and researching. I mean, you basically need a PhD in order to do, you know, one small point-and-click task well. When you put a DPIA in front of somebody and say, okay, now let's talk about, you know, ephemeral human risk, just brain melt, because the amount of knowledge that you have to have in order to be able to consider that in the first place is enormous, and you can't shoehorn that into a company that's already at 120% capacity in the urgent need to reduce headcount. So yeah, and I agree as well that going back to the analogy of the abusive relationship, most companies' pronouncements on data protection amount to gaslighting. They are a deliberate, possibly unintentional, but still deliberate effort to convince people that reality is not how they experience it, but it is how the company says it is. And I think that's really tied up in a lot of corporate social responsibility and ethics work. But the fundamental problem is that you can do right or you can do well. Pick one. And it is not the corporate, certainly not in a profit-making company's interest, but also I see this in charities and in public sector as well. There is no incentive to do right.
So good at these turns of phrase.
Yeah, well, I never worked as a privacy lawyer inside a company, so but I have two thoughts on this about the culture. I think in my observation as someone who works in a consultancy part-time is that you can really see the influence of culture depending on where it's coming from. So for US-dominated like multinationals with the head that decides on policies and things in the US, sometimes I see this internal fight where the European entities actually hire lawyers to push back on their American head office saying, look, we have GDPR, we cannot do this. But so that kind of says a lot about the influence of corporate culture, that actually within the company, some entities need a lawyer to talk to their mother company. But at the same time, when I think about how to solve the problem, so I agree that general terms like, for example, legitimate interest balancing, you have to balance the risks to fundamental rights against the legitimate interest of the company, but you really have to have a lot of knowledge on what those risks actually are, and you need special training and special education. I don't know if any data protection course would even teach you about it. So a lot of people just get into some sort of stupor and say, okay, just tell me 1, 2, 3 what to do. But at the same time, if you do the 1, 2, 3 and tick boxes, then you get into these bureaucratic procedural mechanisms that completely miss the point. But then the question is, like, what's better? It's like a catch-22. If you make it principle-based, then nobody really knows how to deal with the principles. If you make it procedure-based, then the procedures just wash out the content. And for me, I have not found I don't see a solution, because public enforcement, as I said, also is under-resourced. And also, I think in Europe, the DPAs, they also think in terms of transparency. When there is an investigation, the DPAs look at the privacy policies and say, oh, okay, you violated this and this, you didn't disclose, okay, rectify, here's your fine, and then move on. But what happens on the ground, it just continues happening. The privacy policy changes, but nobody really knows what actually is going on. And yeah, that's kind of more of a puzzle than a solution.
Which hints at, one quick addition, which hints at I think, a slightly different perspective that I have than the way you framed your comments. You framed your comments as there is a disconnect, right? There's one thing that happens here, and then there's something else that happens here, a disconnect between corporations and DPAs, corporations and people. But actually, I think there's far more uniformity in that, just as Svetlana was saying, everyone is focusing on transparency, right? Everyone is focusing on notice and choice. There is, even with the GDPR, which my pro-GDPR American colleagues keep reminding me is not a notice and choice law, but then when I tell them that, well, 90% of the permissions for under GDPR are through the consent option, then it still operates with a consent option. It's that there's too much similarity. The discourse is too pervasive in that if it were different, if corporations thought about it one way and data protection agencies thought about it a different way, you could imagine that we could find some way to fix that. It's that they all have one similar view about what privacy is. It's all bad, and that's the problem, right? Like, it's gone too far such that the only way to fix this is either to, fix capitalism, or destroy capitalism, or to, change our performances from the ground up.
Okay, next question. And actually, you were also waiting, so I propose that you can go first. Like, we'll take 2 questions and then do a round with 2, if that's okay. Comments, questions.
It's more of a comment than a question.
Yeah,
I
that's
think
fine.
There's a broad cultural problem here, in that we're talking about the GDPR as if we hadn't had law since the early 80s, or even Directive 95/46 talked about safeguarding fundamental rights and freedoms. But I think as a data protection officer for a long time, that's why I'm off blonde, I think that one of the easiest ways to do is consider removing the Facebook comma from the key opening sentence in privacy notices that says, "We take your privacy, seriously." So,
thanks for that provocative comment. Thank you very much. So there's another question here in the front. Yeah. Or a comment. Yeah.
It's more of a question. I heard some talks about corporate interests being misaligned with data protection. And some solutions, including switching up capitalism. But are there things that are actually within reach, improvements that can be made now to improve these cultures within companies?
Great question. What is the way forward here?
So I don't think there are any ways to do that within the current model that we're looking at now. The current model for privacy and data protection legislation, and I'll mention that why I conflated the two in a minute. The current model is either GDPR compliance and individual rights, or only individual rights, which is what the states in the United States are doing, and the Federal Trade Commission, which all of those still rely on internal compliance monitors or internal these ethics modulators are adding friction within the system. All of those systems are managerialized. They are all function through the interests of the corporation, through the interests of management. Those things are not going to help. Hiring AI ombudsmen. Which are these ethics moderators, hiring these data protection officers or these privacy professionals, even saying that they report directly to the board of directors, or their salaries come from trust, even those kind of things. Those are internal. Those are always going to be manipulated. What I think the only real answer is radical changes in public governance. So I'll just throw out one. There are many, but I'll just throw out one. One of the things that happens in the United States is that a private company will develop an algorithm to do something. It'll be to help another private company or a public agency hire people, or to help a public agency allocate Medicaid, the part of our healthcare that is single payer for low-income people. And when it goes wrong, right, when the hiring algorithm is discriminatory against persons of color, or when the Medicaid algorithm takes away benefits from people who deserve it, someone will sue. But the company is protected from liability because their algorithm is protected by trade secret law. Right? They are protected from revealing the factors that went into their algorithm or the data that they collected to build this system, because if they shared it with a court, if they shared it in the world, their competitors would just take the algorithm and then beat them to the punch. So one of the things I think we should do is we should eliminate trade secrecy protections when an algorithm is used to make decisions about people. If you want to sell your algorithm to a public agency, to a company, to make decisions that are more efficient, less friction, or so forth, if you want that privilege, you don't get trade secrecy because you are the ones responsible for the decision. Now, when I say that to an American audience, especially if there are intellectual property attorneys in the audience, I get gasps and hisses, and someone once threw like a banana peel because they just ate the banana. So because trade secrecy protections is a gazillion-dollar industry in the United States, and eliminating these kind of things, as well as making all these reports public and allowing for organizational standing, to allow organizations to sue on people's behalf. All of these things they don't rely on companies behaving any better than they do now. Any law that we pass or any change that we need has to start from the presumption that companies are all they want is profit. They don't want anything else besides that. And then public governance tools need to be built as counterweights to that.
May I make an yeah. I mean, I fully agree with you on terms of on principle, but I have a very pessimistic comment to make.
I have a pessimistic
because it's not. Unfortunately, this is not just a matter that country can decide anymore. Because there are trade agreements. There is a TRIPS agreement at the WTO, and even more so, the TRIPS agreement has trade secret protection in it, but the new trade agreements, the so-called digital trade agreements, they have additional provisions on protection of source code of AI algorithms and prohibit countries to require disclosure of those algorithms as a condition for that algorithm to operate. So, I mean, sometimes these trade agreements, they really get only discussed in the trade circles, and sometimes they slip through the attention of information law lawyers. But these trade agreements, they put very serious limitations on what countries and regions like the EU can and cannot do. Mm-hmm. And that's quite dangerous, because those negotiations, they're not even public. They're not discussed. There's no public consultation. You only see the text when it's already agreed on. And that's unfortunately how certain things are getting done on an international level, and that it's very hard to push back.
Mm-hmm. I've got a bit of a different take on that. I don't have a massive amount of faith in the idea that public governance reform can gain traction, because people will be people. Mm-hmm. And any corporate entities, whether they're for-profit or they're governance or they're non-profit, they all act in the interests of the corporate entity first and foremost. And so countries that have not been under capitalism had pretty much the same problems, only in different flavors. Mm-hmm. So if you look back at human history, what happens when we get hold of a new technology or a new idea is we thrash the hell out of it. When the damage to people reaches critical mass, then we decide to do something to prevent that kind of damage occurring again. And then over time, it kind of evens out, by which point we've moved on to the next really dangerous technology, rinse, repeat. So my perspective is from the individual human point of view. Really, the best we can do is ride it out, protect you and the people you love, and go down screaming.
What a way to end CPDP.
we have a question a little bit in the back, like halfway there. Yeah. And so, and this will be actually the final question, and I'll give you a chance to just like quickly respond and give a final comment. Thank you. Yeah.
Okay, I'll stand up. I'm Maggie Pengile from the University of Leeds. First of all, thank you to all the three discussants for this very fascinating talk, full of informative ideas. Professor Waldman, I would have a question directed to you, and you would pardon my silly asking, if it sounds like this, but you have conducted your research in technological companies. Are they defense related? If not, how much would your context of ideas, finding, and methodology would differ if you would be conducting your research into defense companies, defense technology? Thank you very much.
Interesting question. These companies, as far as I know, I'm not privy to all of their contracts, but the particular products that they were talking about in the meetings that I was in had no connection to the defense industry. Big information companies like Amazon and Facebook, even smaller companies like Constant Contact. A lot of these companies have incidental contracts with other companies that are in the military-industrial complex. But nothing that I touched or any meeting that I attended was directly connected to anything defense-related. Would it change my mind about how I felt about what was happening? Well, I'm not sure. I mean, I don't think the substance of the industry matters so much for the managerialization of the process of what's happening, right? I also don't want my country's immigration enforcement bureaucracies of violence to have all of this data on people that have more melanin in their skin than I do. So if those companies and the agency and government agencies that are involved are engaging in the same type of managerialism, the same type of manipulation of the discourse, the same type of structural obfuscation and overtaking of individuals from their dissent, then I would say the problem persists. But I haven't given significant thought to that question.
Thank you. I'm actually seeing we just have 2 minutes, so I'm just gonna kind of wrap it up. But I mean, I can imagine maybe in the defense context there being kind of less of like a power in the consumer choice kind of like framing of things, because I mean, a lot of those kind of like information systems don't have like a consumer choice type of interface, you know. It's like so in that sense it could be, but there may be another discourse that is very dominant. It is not necessarily, you know, about caring for the human, you know, caring for. I have a great sense of like, I think what came out in the discussion and also hearing from like practitioners, you know, that doing justice to the principles underlying like the GDPR and data protection and fundamental rights, it is a lot of work, and it can be very overwhelming in a way for individuals within organizations, and like I just hope that we can find a way to empower people, you know, like and one of the things I would say on discourse, you know, I have not given up on like that kind of being also a battleground and a place where, you know, like there's different kinds of like kind of entities and actors and communities contributing to that. And you know, maybe, you know, like with the data protection authorities and the regulators and public institutions in Europe, that can at times be very helpful. And I think civil society has played at times a very important role. Maybe academia could sometimes do a better job at like contributing critically to the discourse. And with that, I think I will thank you again, Ari, for being here with us and for opening up your mind and speaking about your research. Again, compliments on this terrific piece of work, and we look, of course, forward to seeing more work coming out on the future.
Thank you so much for organizing this, and thank you all for coming, and thank you for commenting on the book and for taking the time to read it.
Yeah.
Thank you so much.
Thank you.
That was great. Thank you.